want to talk a little bit here about the stages of negotiation, and this is something that people have a problem understanding the necessity of utilizing. So we talked about the premise yesterday of thinking that you've been negotiating since you were an infant, 3 years old, 10 years old. When you wanted your first car, you negotiated with your parents, you built a campaign. It was a perfectly executed marketing campaign, better than most advertising firms on Madison Avenue could do in New York. And so you think to yourself, well, why do I have to follow this plan? What value is there to this negotiation preparation form? This doesn't even make sense. I don't get it. Well, let's think about this. If you've ever flown in an airplane, or maybe flown an airplane, or do fly an airplane, there is one thing that every pilot understands, no matter what, and that is that you have a checklist that you must use for everything you do with the airplane. And that includes when you get to the airport, you do a pre-flight checklist, you go through the same checklist every single time, no matter what. When you take off, you have a checklist. Every pilot that flies a commercial airplane has a checklist for every single thing they do in the plane. No matter how many years they've flown, no matter how many heroic events they've been involved with, no matter how many medals they've earned, no matter what, they must follow the checklist, period. And there's a reason that they do that. And the reason is that the more frequently, or the fact that they use the checklist every time, will prevent pilot error from occurring during a flight. So obviously that's important. Then you have doctors. And as I'm sure you know by now, there are many medical malpractice lawsuits filed every single year. So what do you think is one of the biggest reasons for the filing of a medical malpractice suit? Is it that the doctor has not learned the most up-to-date method of performing a highly complex surgery? Is it that they just, weren't real competent with their ability to suture someone or actually perform whatever operation they were doing? What do you think is the #1 reason that most often results in a med mal claim? You'd probably be surprised to know that it is one of the most fundamental, stupid things that it could possibly be. And that is simply that the surgeon operates on the wrong body part. So if you come in and you have a right shoulder issue that requires surgery, the doctor ends up doing surgery on the left side. Well, that's really not a good plan, is it? That just doesn't make a lot of sense. And it certainly doesn't make the patient feel that the physician cares or understands what's happening, and that's why you end up with so many lawsuits. But you have to wonder, how ridiculous is that to not know which side you're operating on? I mean, that just seems kind of so fundamental, and that's the term, so fundamental. So many doctors have fallen into the trap of thinking that they've spent years in school, they're scientific and medical geniuses, and they have all these accolades and skills. They don't think about the fundamentals, the basics. Now, if you recall in the original video, what we talked about is what separates gold medalists and professional athletes from everyone else. Their ability to master the basics. And that is so often what we forget because we get so caught up in our own branding and messaging and self-marketing that we stop thinking about how to make sure that we follow the right path and that we don't cut on the right arm when it's the left arm or the left knee when it's the right knee, right? Because that isn't the way to have a successful outcome. Because our job is to get the best possible outcome for our client. That's it. It's not more complicated than that. So if the doctor's number one med mal issue is operating on the wrong side, then what do they do to fix that? Well, like pilots, having a checklist, doctors now, and if you've been to the hospital for any type of surgery, you will have already seen this, but doctors now have literally everyone that you come in contact with specifically ask you to confirm for them what you're there for, what's being operated on, and most importantly, what side is being operated on, right? So that fundamentally resolves the problem of cutting on the wrong side. That's good. But it's so simple. Why did that have to take so many people having to file so many lawsuits against so many doctors? Well, because, believe it or not, and I know that you've never encountered this here at law school or in your life to this point, which is great, but there are people in the world that tend to believe after a certain point their own smug. And so I know many of you will be watching this, and we're going to spend a lot of time talking about this very fundamental, very basic checklist for negotiations and say, well, you know, this is just ridiculous, it's too fundamental, I don't need this because I am an awesome negotiator. I got that last car deal. I mean, everyone said, my friends all said that was the best deal anybody could have obtained. So this is ludicrous. Well, we'll see as we go through this, and I know a lot of you will just toss it to the side, like a lot of things in law school, but I hope that you do take with you the concept that sometimes smug doesn't fit in well with our ultimate objective, which I'm going to repeat again, is the outcome for the client. So, what is the first stage for negotiation? Well, that does seem fundamental, but and this is going to differ slightly from the text, but I'm gonna basically make this easier and more fundamental, and we're going to put this in a 6-section breakdown for negotiations, for preparation. So. Or for negotiations, but the first stage is the preparation stage, and so that's where we really want to understand our client and our client's needs. Now, you know, that seems so basic that why I would spend some time now talking about this just makes you kind of scratch your head. But here's the problem. In most firms, what you have is you'll have a client call. And they'll say that they want to set up an appointment because they've had maybe an injury. And so the intake person sets up an appointment, and you know, the attorney says, well, you know, I've got a motion hearing that morning, and then I have golf in the afternoon, and I mean, I'm not going to be able to do this. But you're a paralegal, so why don't you sit down with Mrs. Jones, and you talk to Mrs. Jones, and you get the information, and I will, you know, I'll be able to catch up from there, and you lay the foundation, you lay the groundwork, and we'll all be good. So that is the way things start. Well, then the first meeting then was with the paralegal, and so a few months later, there's been a lawsuit filed, and there's a motion by the other side to dismiss the case, or maybe for a summary judgment. And at that point, you you look at the case and you go through it, there's hundreds of pages of medical records, there's police reports, there's all kinds of discovery, and you're overwhelmed, and frankly, you really don't understand the fundamental aspects of the case. Well, you go to the summary judgment hearing, you get through that by the skin of your teeth, maybe, or maybe you don't. But then ultimately the case goes on, as most cases do in litigation, for a year, year and a half, 2 years, and you get to the point where the judge says, have you sat down and talked about settlement of this case? Well, no, you haven't done that yet. So you sit down, you talk to your client, you meet with the other side, maybe you do it with a mediator, depending on the jurisdiction. Maybe it's kind of haphazard and you just meet at the courthouse, whatever, who knows. But you sit down and you talk to the other side, and they say, we have an offer to make to settle this. And you go, great, what is it? $5,000. Well, you've been litigating the case for 2 years. You spent probably $30,000, $40,000 in fees and experts and all this, and you're like, what is that based on? Well, turns out the other side may have videotape surveillance of your client, may have some smoking gun about something that your client did that maybe had nothing to do with whatever the claim's about. Maybe the claim is involving injury to the shoulder, and your client has years and years of identical problems with the same shoulder. Some issue comes up, and now you're in the position where you have a client that you are going to tell that the opening offer, and maybe the final offer, was $5,000, and how are you going to explain that? The client's going to say, what are you talking about? Because I still owe you, whatever thousands of dollars for the expenses for getting this case ready to go to trial. That's a tough discussion to have with a client, and unfortunately, that exact discussion is all too often what occurs between an attorney and a client. So, that begs the question, what's the answer to that problem? Well, like with pilots and with doctors, the answer is you cannot put the initial meeting and information gathering process on someone else. If you do that, it will not work well for you. What? I have the best paralegal on earth. She can draft better complaints. She can draft better responses to discovery. She can literally do everything better without a law degree. I rely on her for everything, or him. It's the best thing in the world. It's better than Wonder Bread. I have never seen anything like it. So I totally trust them to handle any client's issues. Well, you cannot entrust this particular area to anyone else. Because in order to understand what someone else is thinking or doing, or to get an intuitive sense of what is happening, there is no substitute for you physically, person to person, sitting across from someone and having a discussion with them to understand all of the fundamentals of their case. Now, we also talked about a fundamental problem yesterday, that nobody likes lawyers. And even our own clients don't care for lawyers. I mean, that's just a fundamental, unfortunate truth. So understanding that concept suggests that your client may not be 100% forthcoming in a discussion with you and your client. Now, you might be wondering at this point, what the hell does this have to do with negotiation or with anything else? Well, we also talked about a fundamental premise yesterday that truly exceptional results and anything that you do with where you want a very good outcome in a case involves a lot of psychology. It involves understanding your client, it involves understanding yourself, and it involves understanding your opponent. Because you cannot navigate the litigation jungle at all if you don't understand fundamentally those three things. You have to be able to understand that. Now, I'm going to posit here, and this is going to shake you to the core unless you're over 40, but you cannot effectively meet with a client over the internet, over an email, even FaceTime. You can't do that. Now, I'm not saying that you can't use technology for all kinds of awesome things. Follow-up meetings with clients and all kinds of things. But that fundamental meeting, that first time that you sit down with your client and you want to truly understand, because if you're looking at this checklist, you know that we have some basic things that we have to identify with our client, right? Because we want to know what's essential, we want to know what's important, and less important, desirable. But we can't understand some of the most basic fabric of what's happening in this case if we don't have an opportunity to look at someone face to face. Because as we're going to talk about a little bit later, there are cues that we can look at in people that will suggest certain types of issues. It may be deception, it may be uncomfortability, it may be whatever. But you won't be able to really ascertain that if you don't have an opportunity to sit down with someone and look at them and assess them. So if we understand fundamental basics that people don't like us to begin with, they don't like attorneys, even their own, then we know that there's an opportunity that someone may come in and at first blush, they may not be completely forthcoming. Well, why is that? Is it just because they're not forthcoming and maybe they're lying and they're just a piece of crap? Well, maybe that is, but then again, maybe it isn't. Maybe there's other reasons that someone may be less than forthcoming. Maybe there's a fear factor. So you've been in law school for at least 1, 2, maybe 3 years, and you have become entrenched in a sort of a lifestyle, but more so a mentality of thinking and of interacting day to day with individuals. That really is not normal anymore. I mean, we are not normal people. That there is nothing normal about you after you finish 3 years of an indoctrination in law school or medical school or anything else, because your thought process now is completely different. One of the problems is that at this point in time, you haven't even obtained your license, and yet you understand some fundamental things about the process. Well, what's really hard to think about and remember when you sit down with a client, whether it's 1 month after you've graduated, 1 year after you've graduated, or maybe 20, you really can't remember that everyone else that is not part of this experience doesn't know and doesn't understand what is going on. And so when people are afraid or intimidated or both, that makes them act and behave differently than they would if they were completely comfortable. So one of the things that you want to think about in that initial client meeting is to create an environment where you can make somebody feel comfortable about the process. Because that's the one thing that you own or will own, is understanding the process from beginning to end. Now, you know, and I know, and you probably don't know anybody like this in law school, because goodness knows that nobody in law school has mental issues or psychological whatever. But there are people with obsessive compulsive disorders, and that's if you've never heard that and you haven't seen it, I get it. But a lot of law students and lawyers seem to have some of those propensities. So you might like to have things lined up in a certain way, organized in a certain way, because then you understand what's going to happen from the beginning to the end. So you might have a schedule for your classes, for your life that is set from 6 a.m. Sunday morning until midnight Saturday night. And everything, every hour of the day is set for you, because that gives you a feeling of security and knowing that, you know, Sundays, Monday, Tuesday, Wednesday, every day you know what you're doing and you feel secure in that, right? But think about having been involved in an injury or in some sort of trauma where you're injured and feeling vulnerable because you're already not feeling well, for whether it's physical, mental, emotional, whatever it might be, and now you're involved in a process that you actually don't know anything about, you don't trust, and you don't know the lawyer. So as a client, you are really in a very difficult position. The point of this is one of the most fundamental things in your life, professional life, that you can do is to take the time, play one less golf game, play one less table tennis game, or just play it later in the day, do whatever, but you must spend the time that it takes initially to meet with that client and make them feel secure in understanding that you, first of all, understand what their case is about, but more importantly, what their concerns are. Because you can't know what the case is about in reality if you don't understand their concerns or their fears or their whatever. Now, there's more than just one reason to do this. Obviously, one of the main reasons is to make them comfortable with you and to help guide them through the process, and teach them about it, and have them understand what they can expect from the process. But by making somebody feel truly comfortable and that you actually understand and empathize with their situation, with their actual situation, it will allow you to have a more forthright conversation with them, and most importantly, for them to tell you everything, because it's the one thing that they won't disclose to you or they won't share with you that will be vitally important in the case. And if you knew about it up front, you could have easily dealt with it. But when you find out that there's a smoking gun, you know, when you have your final settlement sit-down meeting 1 week before a trial begins, that is not the time to find that out. Trust me, your sphincter will go into overdrive and you will have a really bad rest of the day, because there's nothing worse than realizing that, you know, your case has got a huge crack, like your windshield. There's a huge crack and it starts off like a tiny chip, and then over time it gets all these little veins, and then at some point it just goes. So the other side is always working that angle, right? The other side is always going to chip away, because most people know, you know, most lawyers know that, you know, if you got to school, you got through school, you took the bar, you passed the bar, it's, you know, it's not rocket science. I mean, most lawyers are generally fairly intelligent, and it's not like, for the most part, you're not going to be going up against you know, an F. Lee Bailey or a Johnny Cochran. With that, you know, what makes the difference then between one over another? Well, tenacity, drive, and hard work. And so the other side is always going to be looking for, if they're good, and maybe they won't be, but you can't always rest on that, chip, chip, chip away. Because like a windshield, one small chip in a windshield, in a piece of glass that begins that way, can blow up and destroy an entire windshield pretty quickly, really, depending on the temperature. So same thing can happen with you. So I cannot overemphasize, I cannot stress to you enough that in order to get to the end of your game, which is outcome, if you recall, and most of you may not have heard this, but the term GIGO or GIGO, garbage in, garbage out. You must have real, substantive, important, complete information at the front end of your case in order to understand what you need to do to navigate the negotiation process and every other process that you may be required to do during the pendency of the litigation. So I cannot emphasize enough how critical that is, and that cannot be delegated to, Susie Q or Bobby Q or anybody else, because you will not know. If you all have an intuition, a sixth sense. Now, most of us, as we get older, we know, if you think back to childhood, I guarantee you that you had a pretty good intuitive feeling that if you were going to approach your mom, dad, aunt, uncle, whoever was taking care of you, and you were going to ask them for something, you could probably gauge if that maybe wasn't the best thing to do at that moment. Because maybe they were angry, maybe they were sad, maybe they were just in a bad mood and it wasn't the time. So you wouldn't poke them and then let them bark at you and then run away, or you wouldn't just dump out whatever it was that you wanted. No, you had the intuition to know, you could sense that there was a problem. Well, we all have that. We all tend to bury it, and frequently we feel it, but as adults we just push it back farther and farther to the point where we just begin to think, well, we don't have that. That's just poppycock. And even if we had it as kids, we don't have the skill, we don't have the ability anymore. But that's not correct. We do. So the reason that I stress to you the need to sit with a client is because if you're talking to a client, you say, well, have you had problems with your shoulder or your back or headaches or with dental problems or with psychological problems in the past? And they say, no. A paralegal may not care, or even if it's that they care, they may not understand the impact of the facial function that will immediately tell you, okay, I have to ask a follow-up question here, that this is not rocket science. I have got to ask a follow-up question because I think there may be a problem with a past issue with the back, that, headaches, whatever. So other people will not intuit because they either don't care or they don't understand what the reason is to connect with that intuition, but you can call it common sense, you call it whatever you want. You know that when you see that behavior, you must follow up and react to it. Because if you don't, that's going to have an impact on this. And the more of those kinds of problems that you miss, right, the more this is going to fade away. And eventually it's going to completely disappear. And unfortunately, many, many times, it disappears 1 week or 1 day or 3 days before trial. And that is not where you want to find yourself. That is really not what you want to do with your situation. So, meeting with your client, an absolute critical necessity to get the information that you need to properly understand every aspect of the case that they're bringing, understand their background, understand their motivation, and be able to begin. And sometimes this can't happen on the first meeting. Sometimes it takes a follow-up meeting in order to really understand and to get this. So, frequently it's not a bad idea to use the first meeting as a tool to kind of go over some real basics, but to get the client really comfortable with you and to get, make sure that you're gelling, and that, because by conveying to them the basic information about how the process is going to work, you're going to create an environment of more trust, and they're going to want to come back to see you if they really think that you're connecting with them. One of the things I want to really hammer on also, because, well, this is a massive problem with everyone today, but all of what I'm talking about today is for naught. It's worthless if you don't know how to listen. And because everybody under 40 basically, because your life is this, it is, that is our soul today. And because of that, because of iPads and text messages and emails and constant barrage of incoming data, we have seriously lost the most fundamental ability to listen. Now, here's where the train goes off the rails, because now I've got you upset. What are you talking about? Well, I listen every day. I got to listen to this crap lecture about negotiation and look at these stupid outlines. What are you even talking about? Well, what I'm talking about is this. You do listen every day and you do hear things. The problem is there's a huge difference between the listening that you do day to day, when you hear the radio, when you hear a podcast, when you listen to something on your phone, whatever. There's a passive listening that you do all the time. That's how most of us function, is with passive listening. The problem is passive listening is not going to work if you really want to genuinely understand what is going on with your client and genuinely convey that you do understand. Because there are a lot of lawyers that, like with their wives, husbands, whatever, significant others, they've learned to listen very passively, right? And they can nod their heads, at an appropriate time, or even give a response that sounds quasi-appropriate, but they really don't know what's being said. They just hear this because we're inundated all the time with information, all the time. It's constant overload. So we have to do something a little bit different when we want to go into an active listening mode and really understand and convey that understanding to the client. So what the hell is that? Active listening. You have got to make a conscious decision when you sit down with someone and you really want to understand where they're coming from. And as we go through negotiation, you'll realize this is critical to the process of you really getting the other side's point of view as well, because that's really important when we get to the heart of things. But for you to truly understand what your client wants, what's essential, important, and desirous, you must be able to go into the mode of active listening. Now, I'm going to provide a link to a video that talks about the how and the benefits. And you at some point are going to have to make a decision whether you want to even acknowledge that you to this point are probably and have been really not utilizing active listening, because I'd say less than 5% of all law students ever actively listen. Because there's one thing that law students love to do, and that's to talk, because they got so much to say. As lawyers, lawyers love to talk, which brings us to the kind of opposite situation here. So, what we want to do with active listening is we want to actually listen to what our client is talking about, and in order to let them know that we do, we're going to give them feedback. What we're going to do, and this again sounds very fundamental and silly, we're going to tell them kind of what they told us, but in a summary fashion that we can understand and embrace. And we're going to put it in our terms so that when we file a lawsuit or we do something, it makes sense and it interrelates. So we're going to talk back and tell our client what they told us, but in our words. That is a fundamental aspect of active listening, because now you actually own this information. And as I'm sure most of you are not doing right now, is taking notes. The act of doing this is what actually lets you absorb the fundamental basics that you have to have in order to understand your theory of the case and get to your BATNA, right? Your best alternative to a negotiated agreement, to do all the things that are absolutely essential for you to get to the best outcome for your client. So active listening is critical. But there's a tool that we can use that will actually make this process better and more effective. It's a tool that shakes lawyers and law students to the core. It scares them more than punitive damages, anything. And it actually scares pretty much everyone. And even if it doesn't scare them, it makes them really uncomfortable. And what happens most often when someone is uncomfortable? They talk. But how do you get them to that point? What tool? We've talked about having a toolbox, whether it's a tool belt or a box, whatever. We have a box. And we have lots of tools in them. We talked about mediation, arbitration, collaborative law, blah, 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 all these things. But in this toolbox, we have a tool. We don't have to buy it. We don't have to maintenance it. We don't have to change the oil in it. We don't have to worry about air filters. We don't have to do anything, because it is something we all have and can do like that. Pretty scary. Wow. That word, you don't see it that often. You don't want to think about it that often. But what a powerful tool. Did you ever wonder, stop and think, we have 2 ears and only 1 mouth. And so often, Lawyers fall into the fundamental trap of vanity and arrogance. And they love to vomit. They like to vomit to their family, they like to vomit to their coworkers, but they especially like to vomit to their opposing counsel when they get, in a room with them alone and talk about, fishing, talk about hunting, talk about, golfing, whatever the hell they like to do. They love to talk a lot because lawyers get confused and they think they have two mouths and just one ear. Now, I'm not sure how they confuse that, but anyway, they really do get confused. This is one of the most powerful tools that you will ever possess, ever have at your disposal in your arsenal, day in, day out, 24/7. Silence. The power that you can have with using silence well-placed and well-timed. Have you ever been silent with someone? What happens after just a short amount of time? You know what happens. They have to talk because they can't stand the discomfort. That's even true in your own life with your own family. People, for the most part, are really uncomfortable if there's a certain amount of time that goes by without talking because they think there must be a problem if someone hasn't talked. Sometimes, honestly, most times, talking is way overrated. But what isn't overrated for a good lawyer, for a lawyer who's, and I'm going to repeat this again. Now, whether this repetition has anything to do with something that you might want to take a note about, I don't know, but it could. And it might not, but. All right. A lot of this is going to come back time and time again to some of these basic fundamental concepts, but it's about being an intentional advocate. An intentional advocate. What does that mean? People really, the two words that I use that seem to scare people beyond description is silence and intentional. They must be really way more complicated than I think they really are, or whatever, I don't know. Hopefully you've got some basic framework and understanding about the word silence. But this one gets trickier for people. Intentional means that everything you do has a purpose. There's an intent. And that you understand that by doing something, it's not just on a whim. It's not just because you woke up and you thought, I'm just not feeling it today, so I'm just going to do X, Y, or Z. No, you planned last night that you're going to meet with your client. But this meeting, this is a second meeting. The first meeting, because you remembered from your horrifically long and horrifically boring lecture in ADR about the need to make that first meeting with a client to make them comfortable. So you have a follow-up meeting to really get the meat and potatoes of the case. And you've done that. But you're planning this now and you're doing it in an intentional way because you know what you need to get, you know what you want to get from your clients. I mean, you need them to be forthright and to open up to you. Now, most lawyers on a second visit will sit back, sip an iced tea, and tell people about how many awards they got or how many cases they've won and start self-aggrandizing. Because lawyers love to self-aggrandize because they're so awesome. So when you start that, you have a client now that has built up a rapport and a trust with you and now sits back and goes, damn, what did I just do? I don't know who this person is. But because you're an intentional lawyer, you said, I'm not going to do that. My purpose is today to get information that I need and that I have to have if I want to pursue this case effectively and to get the best outcome I can as an intentional and purposeful advocate. So I'm going to utilize the process of active listening by being silent. Unbelievable how that works. When you use it properly and you built a rapport with someone, because you'll scare somebody if you use this before you have built a rapport. But once you've built a rapport with your client and you utilize this, wow, you'll be amazed at what you'll get. Because now you're using what we've been given to gather information, which are 2 ears and 1 mouth, and this stays closed, and we listen and absorb everything we need through using silence from us and letting our client actually talk and tell us the things that they want. Now, in order for us to understand the very nuanced differences between what is essential to a client and what's important, well, that's a real splitting hairs, nuanced kind of thing. The way we're going to be able to really understand and make sure they understand that we get it, right? That's going to be through active listening and by repeating back or conveying back to them our summary of our understanding of what is going on and what they need, what's important, what's essential, and what's a desire. And there are some big differences between, for example, what's a desire to get from a case and what's essential. All right. I think that's where we'll stop right at this point and pick it up here in a minute.